Hello, everyone. Thank you very much for joining us today. If you haven't already met me, my name is Cassidy Sorry, and I'm the Enterprise Manager at this University of St Andrews Entrepreneurship Centre. If you haven't worked with us before, let me briefly introduce a little bit about what we do. So the Entrepreneurship Centre is committed to fostering entrepreneurship both within the university and the wider community. And we support individuals at every stage of the entrepreneurial journey, from helping aspiring entrepreneurs to get started, to assisting early stage ventures, and supporting the growth of small and medium-sized enterprises. So we really work to connect industry with our staff and student community to create a dynamic and thriving entrepreneurial ecosystem. We do this in a variety of different ways, such as programs, one-to-one support, and events like today, to provide you with the tools, resources, and guidance to bring research and to life and develop successful ventures, which will create lasting impact. So if any of this resonates with you, or you'd like to find out a little bit more about what we do, then please get in contact. I will be sending out an email that has both the Entrepreneurship Centre and Alex's contact details after the session, and I'm sure Alex will pass these on to you as well during the session. But before I do pass over to Alex, who will introduce himself, to a little bit more about how you can help you on this journey. If you do have any technical difficulties throughout, then please do let me know in the chat, and I'd be more than happy to help with that. There is also time at the end of the session for a Q&A, so if you have any questions throughout, then we encourage you to put them in the chat so that Alex has a lovely bank of questions to go through at the end. But I think that is everything from me. So if you're ready, Alex, I will hand over to you.
Thank you, Cassidy. Good afternoon, everyone. You've got me just on my own today. It was going to be a sort of duo effort with my colleague Matthew, but he's unable to join, so I'll just be talking to myself, I guess. But looking forward to talking to some of you as well if you've got any questions. So I will just kick off by telling you a little bit about myself and MBM Commercial. So the firm is actually 20 years old this year. We were a spin out of a larger firm 20 years ago. We wanted to focus on entrepreneurial ecosystem, startups, spin outs, scaling up companies and taking them to exit. So that's what we're all about. We've won many awards. Many of these ones will have all been kind of end of last year, so we kind of had a good run in Q4 last year. Lots of prizes. Uniquely, I guess, in the US, Scotland, is we have this US team. So I'm one of the attorneys. I'm a New York attorney as well as a UK corporate lawyer. We have 4 corporate commercial lawyers here that are all US, and 1 employment attorney as well. The majority of our US attorneys actually built their careers in the US and then relocated to Scotland. So some of them have decades of experience acting and negotiating deals in the US before joining us. And we find we do an awful lot of transatlantic work as a result. We have offices up here in Edinburgh and down in London. We're not too far away from those of you who are up at Walter Bauer today, and you'll maybe see some of us floating around up there now and again when we're up for evening events. Tech Legal Group, this is an international network of law firms that we've built ourselves by finding entrepreneurially focused law firms like ourselves, and we've kind of vetted them and think they're a good partner to work with should we need international advice outside of the UK or the US. So focusing on startups, we deal with corporate matters, so that's anything to do with share capital, governance for your board, things like share options as well. Mergers and acquisitions includes sort of buying and selling companies. So you might actually not just be looking to exit, but you might be looking to buy up some of your competitors, or you might be taking part in an acqui-hire and buying someone just to buy the team. We do various debt transactions. We have an employment and HR team here to help you with that side of things, and intellectual property data and commercial contracts. And I've been with the firm 7 or 8 years now. I've been in the sort of startup ecosystem for about 15 years. I've built and run my own events and networking startup company, sort of on the side at some point, sort of trodden that path a little bit myself, but always been very focused on sort of jumping in and looking to help build a business and really support founders doing that. It's something I'm very passionate about, and I think you'll find most of the lawyers at MBM are of the same kind of mentality. We try to think like co-founders when we can, and think that adds a lot of value. So what are we talking about today? How to get started. Now, being a lawyer and being asked to come and talk about the legal process of starting up a company, this will have a bit of law in it, of course, but it's also a bit boring talking just about the law. So I thought it'd be more fun to talk about rock climbing, which is another passion of mine. And whilst I was in a climbing competition a few years ago, I sort of realized there were quite a lot of similarities in building a business as there is sort of going off on a climbing expedition. So when we're building our first company, getting your startup set up, it's good to start thinking about it like an expedition. We want to plan ahead. We want to try and avoid some pitfalls. But you also want to know where you're going, which kind of means, do you know how you're going to get there? Is it the only way to get there? What's the route? Where do you start? What do you need to take with you to get you from here to there? So I'm going to be really laboring this analogy, I suspect, but it also means that I've not had to pay anyone for all these images. I've just been able to pull these from the bank of me looking terrified as I'm trying to scramble up a piece of rock. So this is the challenge of being a startup founder, right? It's terrifying and exhilarating all at the same time. And it always feels better once you've done the pitching, once you've got the deal done, often than it does when you're going through the experience. But we keep doing it. We keep scaling these new heights. So as I say, if you don't know where you're starting, it's quite difficult to work out where you're going. And we find quite regularly that founders might not understand who owns the company. More so, I'm finding founders are telling us that they've done various things and that they've made filings at Companies House, but that doesn't necessarily reflect the fact that they've omitted to carry out a legal transaction. So it's important to really understand your cap table. And a cap table doesn't have to be anything terribly complicated. It can just be a spreadsheet with who owns what. But you should also understand when you set up your company that you want to make sure you've got company registers. Those will set out who owns what in the company, who the directors are, who the secretaries are, and that sort of thing. And that is the authority for who owns the shares in your company. Companies House is just a filing, a notification, a reflection of what should be in your company registers, but the registers are the authority. So it's a bit like the deed to your house being the authority that you own it. We don't have deeds of ownership really in when it comes to share capital in companies, but we do have share registers and company registers, and that's what matters. Companies House lets you keep some of your registers at Companies House, but not all of your registers, which is really misleading because it makes you think you've covered it all off when actually you might not have done. So beware being lured into thinking that it's all okay by Companies House giving you that option. Typically, it's not very difficult to create a set of registers, and you can keep them in electronic form. So we tend to keep everything in electronic form now, but they should be available. The public are allowed to inspect your company registers, and they're supposed to be able to inspect them at your registered address. So if you've set your startup up at your mum's house, then technically someone's allowed to turn up and knock on the door and say, "Can I see who owns the company, please?" And read those registers, which will come as a bit of a surprise to your mum. So keep that in mind. But also what we find, of course, is that when you're building your startup, there's lots of people doing bits and pieces for you, and it might be you've got a supervisor at the university you're working with and it's more of a spin out situation, and they're going to get some equity, or you're designing and building this company in your dorm room, and your dorm buddy is sort of building the website, and you're like, yeah, sure, I'll give you 5% of the company, you'll get some sweat equity. Are you tracking all of these things? Are they being properly documented? Are people getting shares at the point you set the company up, or have they got to work and do something in the future to earn those shares? should you have a share option? And this is quite important, because when you start negotiating with investors, they're going to want to understand what their stake in the company is going to be and how it's impacted by promises you've made to other people about the shares you're going to give them. So keeping a very clear picture of who owns what, who's on the cap table, who isn't, who's in the share registers and who isn't, is really, really important. And making sure that you've got some written agreements. Typically, you'll find that, you know, investors don't want to see that you've given all these people shares at the beginning, because quite often the people that are helping you at the beginning of a company's life won't be there in the future. So, and there's an exception there, I guess, with sort of spin outs and universities and supervisors and people that might be involved there. But generally, you want to think carefully about that and take advice and talk to other founders, talk to investors and people in the ecosystem about their experience, and make sure you're getting that number right. We find investors complaining about, you know, somebody who's on the cap table who's got like 10% and they've done nothing. You know, they designed a website like 5 years ago. You know, why they're on the cap table. So something to keep in mind. We'll talk a little bit later about co-founders. But something you will come into contact with as you're building out these cap tables and registers is, you know, the shares you own today and the shares you own in 5-10 years, of course, could represent very different percentages of a company. So you might own 100 shares, and that's 100% of the company. If you go and issue a whole load more shares, those 100 shares no longer represent 100%. You know, if you issue another 100 shares, you now only own 50%. You have been diluted. If you have promised somebody through an option that you will issue them 100 shares, then today you own 100% because you have 100 shares and there are only 100 shares in issue. But you have promised an additional 100 shares to someone else. And you haven't issued them yet. So what we would say there is that the fully diluted position is you own 50%, because the fully diluted position will reflect those shares that you've got under option being created and issued in due course. The reason this is important is the shares that are issued today show you what the voting rights are. But of course, we're not just interested in the voting power that we're getting today. We want to know, how much do I get when we sell? In 5 years' time, when we sell this company, how much of whatever we sell it for is going to be mine? Whether you're an investor or a founder, this will be in your mind. So, you know, we're going to sell for £10 million. Okay, I'm thinking I'm getting, you know, a certain percentage, but hang on, there's all these options that are going to be out there for staff or advisors and people, and there'll be a whole load of shares issued to them just before we sell. And the fully diluted position is actually less than my voting position. So I might own 70% of the company, but I might only get 60% of whatever we sell the company for because of that change on the cap table. So that's why investors will always be keen to understand what your fully diluted position is, what other shares will be issued between now and that completion of an exit event. So that's really what I'm just covering off there. It's also important because when you go into a complicated, a more sophisticated investment round, shall I say, and let's say it's sort of £500,000 or more, typically founders and companies have to give warranties, and you will have to give a warranty that the cap table is as you're presenting it to be, that the shares are indeed issued to the people you're saying they're issued to and are owned the way they're owned, and that you've got certain options in play or you don't have any options. And if you're wrong, the investors may have a claim. So you need to really be quite accurate on this and make sure that you have very clear visibility on the share ownership. There's also commercial viability, visibility. So you may have a fog of data and documents that you're sort of surrounded by as you're quickly gearing up and getting things started. So you may have customer contracts, advisor agreements, staff options, staff contracts, all sorts of things. You might have at a very basic level, agree by email that someone will build a website for you and it will cost £500. And yes, you agree that you'll pay the £500 if they do the website, so they get on with it. Well, you've just formed a contract for the purchase of those services. So, that's the kind of thing you would save that email, keep it in a folder, alongside maybe letters giving you grants. That's important as well. So you want to make sure you're collecting all these documents and putting them into what we would call a data room. And investors will want to get in there and have a nose about and see what's in the box that you're effectively asking them to invest in. Your company is a box full of things. You want to make sure that you've got some non-disclosure or confidentiality agreement in place if they're looking at anything in a data room that's likely to be sensitive. But the point is to make sure that you are presenting your investor, your team that are coming on board with a clear picture of where you are, where you want to go, and that will be your cap table and your data room. And that's a very, 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 very big drop there. And you don't want to be presenting someone with the idea that just give you the money, follow me, and over the edge we go, and you've got no visibility. Okay, a little bit about teams. So some of you might be familiar with rock climbers like Alex Honnold, who can, it would seem, just run up things like Yosemite's El Capitan and the Dome, and tremendous feats. Takes really, really good climbers 5 days to get up El Cap. And I think Alex Honnold's last solo attempt up there was it took him 4.5 hours. Because he took no gear, he did it all on his own, no protection, one slip and he's dead. And you call that free soloing. Look, we're not all going to be Alex Honnold. You can get pretty far with talent and determination and enthusiasm, but actually, to get anything done well, you're going to need a team. You build a team around you, and you get over the line together. And for most climbers, you'll find that's the case. They're not zipping up these cliffs on their own. You'll need that problem-solving capability because, as a founder, whether you're on the technical side or the commercial side, you will have blind spots, and you need diversity of thought within your business to help. So, how do you go about building that diversity? So co-founders will typically be where you start. You might be technical and you're never going to be the person that can go out and sell it, or you're somebody that knows how to sell an idea but you haven't got one, and you meet a technical person and they've built something that's really cool. So that's where you see the kind of traditional sort of partnership paradigm between the co-founders. But how confident are you that you're going to stick together all the way to the end? Have you thought about what happens if one of you decides to do something else? It's quite common that you'll find founders say, I've got a couple of different projects running, and I'm going to really kind of spread myself across all of these projects, and then the one that really takes off, I'm going to, I'll put all my time into that one. So you might be one of the businesses that doesn't quite take off at the same pace, and they say, look, I'm going to go and do other things, and you think, okay, well, you own half the company, so what are you going to do with your shares? Hopefully they say, do you know what, the right thing to do is I just give them back and we'll work out how that happens. But quite often somebody drifts off, they go and do something else, and they say, do you know, I don't think I should give my shares back because I actually worked really, really hard for that week where I designed the website, and no, make me. And you think, well, actually, do we have the ability to make them? When you set up a company at Companies House, you could do it quite straightforward and relatively easily by adopting the model articles. And this is a constitution, effectively, that comes in the box. It's really basic, and it doesn't cover any of this sort of stuff that you need when you've got more than one shareholder. Perfect if you've got one shareholder, you don't have to worry. Unless you're going to fall out with yourself, you shouldn't have a problem. But the moment you have two shareholders, these are the sorts of things you need to start thinking about. So founder provisions will either be in the articles, sometimes they might be in a founder's agreement, and they'll cover things like compulsory transfer, which is basically I can force you to transfer your shares if you leave. They might be reverse vesting, which say you own all your shares, but if you leave, we'll effectively undo that, and it will allow you to retain some, but you'll lose some. And then both of these provisions may be dependent on a definition of good leaver and bad leaver. So look, if you leave and you're a good person, a goodie, then you get a good price for your shares, or you get to keep some. If you're a baddie, you don't. And those are drafted very much along quite standardized terms. A bad leaver is someone that commits gross misconduct, or commits fraud. You might see them described as a very bad leaver if it's criminal, and then just a bad leaver if they resign voluntarily. And a good leaver is typically either everything else, or a good leaver might be if you die, if you're critically ill, if you're made redundant. So basically things that aren't really your fault. So that's really important to focus in on when you're thinking about that as a co-founder as against your other co-founder. But it's also something investors are going to focus on, because they're not going to invest their money in your business if you can resign the next day and keep all your shares. They're going to invest in you as much as the business and want to see that you're tied in. And their way to do that is to discourage you from leaving by you being forced to surrender shares if you move on. But of course, you might not just be taking on co-founders. You might be looking at taking on consultants or employees. Consultants are probably where you'll start. You want to avoid being an employer. If you have employees, you've got to be nice to them. You've got to put them on payroll. You've got to give them holidays, auto-enrolled pension. As I say, you've got to treat them nice. Whereas consultants, well, we should be nice to everyone, but you can terminate them much more easily on the basis that they don't have employment rights. However, if a consultant has signed a consultancy agreement, that doesn't in and of itself prohibit them from being deemed an employee. If they turn up to your office every day and work for nobody but you, and they have a desk, and a business card and an email address, and if they look like an employee and sound like an employee and smell like an employee, then HMRC will probably deem them to be an employee. Although please don't go around smelling your employees. I'm told that's discouraged, but you get the point. Be sure that you're on the right side of that one. You don't want to find out later that you've got a backdated PAYE and national insurance contribution liability that you were unaware of because everybody's called themselves a consultant when they're not actually a consultant. But those contracts as well that you have either with consultants or employees will cover key things like intellectual property, things like restrictive covenants, making sure they can't go on and compete, and things like confidentiality. So really important contracts to have, whether they're a consultant or an employee. And you might be thinking, well, okay, what about directors? So, directors can be employees or consultants. If they're executive directors, like the CEO, the CTO, the chances are they're employees, because that role kind of, you would expect and most often demands that they're in the business regularly working for the business, whereas non-executive directors typically are consultants and they might just have a form of appointment letter. You'll typically see an employee contract for somebody that's a CEO, CTO, CSO, notice provisions of 3 months, maybe even 6, whereas a non-executive or a consultant, you might see a notice period of something like 1 month. So it's normally much shorter period. You can chop and change people on a consultancy basis. An example of teamwork there. One of us on the end of the rope whilst I'm clambering up that bit of rock. Okay, so whilst you're clambering up bits of rope and bits of rock, there's all sorts of bits of kit being put in there, and you might not see from the picture, but my colleague there on the ground, he's got lots of quick draws hanging from his harness, and then that rope is going up through some of those quick draws up to my harness. So really useful to have, because if I slip and fall at that point, I'm going to slide down that big slab of rock, but hopefully the rope is going to catch on one of those quick draws. Well, I think intellectual property protection can be quite similar, because it might help prevent you hitting the ground with a very a very hard thud, but it doesn't stop you falling in the first place. So a good strategy is don't fall. That's probably the first thing. And then, how useful is it going to be to have these bits of protection? So if you think about it, patents and trademarks, these are your sort of your protections that you can put in place. They cost money to get and put in place. You then are registering, in the case of a patent, something that might be a secret, you're registering that on a publicly searchable database. That's worth considering whether you want to take that approach. Coca-Cola have never done that. They keep their recipe as a trade secret. It's not publicly available. That's how they've protected it. They didn't patent it. And trademarks, again, like a patent, both of those pieces of protection are effectively a bit of paper that allows you to go to court and say, I was this thing first. I invented it. I called my company this, and everybody knows that that's the name of our business. I got here first, and the other person isn't allowed to use my invention or my name, which is fine, but you have to be able to fund going to court to enforce that right. If you think you've come up with something first and you've got a patent for it, that's great. And let's say Sony infringed that and you decide to go to court and sue Sony. Who's going to run out of money first? You have to think quite strategically. Is it better to have simply kept it a secret? Investors will like a good strategy to intellectual property. It's not a panacea to have a patent. It doesn't necessarily cover everything off. Sometimes speed and agility first to market is the way to go, and you keep things a trade secret. I've seen companies that I've worked with raise, well, I think I did 2 million for them, then 10 million, then they raised another 20 million, and then they sold for 480 million. They had one piece of registered IP, and it was the name of the company. And quite frankly, you could have changed that name and nobody would have cared. They had software. It was kept very secret. There were 3 people with access to source code. Those 3 people were under restrictive covenants that if they'd ever breached their confidentiality and left the business with that source code, they'd have basically been banged to rights. So there was a very different way to approach it. You didn't put everything out there in the public domain. You might also need to be thinking about who creates IP for you and who owns it. So you might start a company. You might be the shareholder. You might be the director. You might have lots of great ideas and come up with some IP. You own that IP. The company does not own it. Doesn't matter that you're a shareholder or director, unless there is a provision somewhere that you've signed up to that says, I'm transferring this IP from me to that other party, whether it be the company or someone else. You have not necessarily transferred any IP. So when you get to your first investment round, you may find investors saying, look, all the IP that you've been working on, whatever it might be, we want to sweep that into the company. You need to sign these transfer agreements, and that's perfectly normal. But it might be at the moment you've got 3 or 4 people working on a project with you. And what's going to happen if between now and your first investment round, one of them drifts off and they were part of the, the key team at the beginning and they contributed some IP? That could be problematic. So you need to keep on top of who it is that's developing IP at any given time, and have you got something that ensures that either you, the founder, get it from them or your company gets it from them. So you might want to do some transfers at certain key milestones. And the moment you get people onto a consultancy agreement or an employment contract, that will say inside that agreement, anything you come up with whilst you're working for this company on this will automatically belong to the company, which makes your life much easier, right? Because it's just automatic and it's always working for you going forwards. Until then, transfers are used, these assignations are used to sort of capture historic IP that's been created and get it transferred across from one party to another. You might think you don't have IP. I guarantee you've got some. Might be copyright, might be know-how. If you've got a clever methodology for doing something, not only is that know-how, but that may be patentable as a method. So that's something to keep in mind. And And sort of alluding here back to that software company I told you that sold for that very big number, made a lot of people very rich. They had a lot of open source software, and the investor team's technical team were very keen to understand what the open source was that was used and what the attributes were. You don't want to have built something that you're pitching, and at the core of that is an open source attribute that says, for example, that you have to take that finished product and recycle it or issue it back into the open source community. Because it might be that there's something in there that says, well, if you use this, you have to post whatever you build using it back to GitHub for the rest of the community to use. That may actually completely undermine your USP. So you need to be aware of that. So I would recommend, if you're working in software, have your engineering or your DevOps teams, keeping a track of the open source, have a log of your open source and the attributes that attach to those different bits of open source. Is the easiest way to do it. Just get into the practice early. So there you go. Bits of kit won't stop you falling, but might save you a bump. I love a climb that's rewarding when you get to the top, because you finished it and you figured it all out on your way, and you're like, not only am I feeling super strong and flexible as a result, but actually it's been a good mental workout because I've worked out all the tricks as I've gone along. That's great, but sometimes you'll be limbering up and getting ready to go, and somebody lands next to you and says, the trick to that one is you just do this and that and the next thing, and you think, oh well, you've kind of given it all away. So don't wander around telling everyone your secret. It ruins their fun, but really for you, the point there is if it's really confidential, particularly if it's core, keep it to yourself. But this needs to be balanced with being able to interact with the ecosystem, being able to interact with investors. You can't completely isolate yourself. And I have bumped into founders at startup events before, and they've said, I'm building a startup, and I've said, that's interesting. What are you doing? Oh, can't tell you. We're in stealth mode. Okay. Like, what do you want us to do? I could be an investor, or it could be someone that could help introduce you to an investor. You can't even tell me what your business proposition is. So you need to be able to interact to a point. You also will find, as you begin to meet investors and talk to investors, you might get invited along for a coffee to talk more about it, to start progressing towards getting the relationship to the point where you go in front of their investment committee and pitch for investment. They will be talking to hundreds of founders. They will not sign NDAs. VCs won't sign NDAs, investment funds and syndicates won't sign NDAs. It would just place them under hundreds of differing legal obligations, and they would never be able to keep track. So the key there is, what can you tell them up to the point where you start to divulge core, technology secrets. You can actually go pretty far. You don't really need to let them in on the secret sauce or let them in under the bonnet, unless they're very technical. At which point you can say, look, we've got to protect the interests of our shareholders, just like we will protect the interests of you, our investors, if you decide to come on board. I'm sure you'll agree it's reasonable that we've taken you so far, but now you want in to have a look under the bonnet. You want to see our customer lists. Wow, that's really commercially sensitive, right? We can't let you know who all our customers are going to be. We can't tell you how the thing works to that level. So that's when you start to have a discussion about NDAs, confidentiality. But don't go into these coffee meetings or jump on these Teams calls and say, I'll just fire you over an NDA on DocuSign, because they'll just tell you that's not going to happen, and they'll be pretty disinterested. So that's kind of my take on keeping things confidential. So yeah, how do we help? Well, we can guide you on all of these things, I think, and look beyond the legals as well. We like to think kind of like co-founders, try and look ahead for you as well, and think about where we can advise. So let us help show you the way. We can talk you through all the kit, make sure you don't fall off the wall as best we can, and help you reach the summit. I'd say you're loving these analogies. They're really being stretched. That's my details there, and we'll share the slide deck following this, and feel free to reach out to me on LinkedIn or X, or just email me, give me a call. I'd be delighted to have a chat, and delighted to answer any questions that you might have. So I'll take us off share screen, and if people want to ask questions or switch on your videos, that's fine. I see one question from Bonnie. So, IP for university staff and students, St Andrews Innovation can advise prior to seeking. Yes, so that's a really good point. Both St Andrews, well, yeah, I know that the whole enterprise team are there to help guide at early stage, and it's, you know, really useful to be going and getting that advice early and understanding what the university processes are, especially with spin out, because you could come and talk to me, or you could come and talk to another lawyer, and they can advise you so far, but actually, you know, you do need to be pulling all the pieces together yourself as the founder, and understanding what the university's processes are, what their timetable is, and having a relationship with them, because they're going to be like your first major shareholder, most likely, and you're going to be using their resources and working with them on campus and things. So it's you know, it's key to have a good relationship with the academic team at the university and also the enterprise team, and make sure you're all working together towards the same ends.
Alex, I had a question around the timeline of all of this, if you don't mind. So obviously you've kind of gone into different details about, you know, the things that people should and shouldn't do. But I think something that's really not considered how the actual length of this process, and sometimes how long or short these could be. Could you talk a little bit around that?
Yeah. So the different things, and I appreciate we ran through things very quickly just to sort of leave plenty of time for Q&A, but different parts of that slide deck might have different timetable. So, you know, setting a company up might take a little bit of time, where you need to work out who's going to own what in the company, what the name's going to be. You might put quite a bit of thought into all of that. Or it might be, look, I just need to get the company incorporated, and I don't really care what the name is. Let's just think of something quickly. Sole director, shareholder, get the thing done, because I need to apply for a grant, and the grant says I need a company, and I need a bank account, and I need to get the company set up so I can apply to the bank. The bank might take 2 months to get sorted, because they want to, I don't know, they want to ID me and my mother and my mother's mother, and, you know, do all their ID checks and things. So there can be a bit of a process there, but you know, I think that one's fairly straightforward. Applying for IP protections and things can take a bit of time if you're doing different searches, but again, I think it's about investing the time in the strategy. You know, your cap table and building that sort of stuff, again, I wouldn't say that was a process necessarily with a timetable, but one process I think which is important in the context of spin out and startup is, if you're spinning out or if you're raising funds, how do you get from simply the desire to do that to actually closing it? In a spin out and a fundraising situation, there's probably at least 3 months where you're going to have coffee meetings and try and get in the interest of the other side. Maybe, you know, more so when you're raising money, because you're out there talking to many investors, whereas if you're spinning out of a university, at least you've got one party that you're talking to. But again, the universities have their processes, and they might not want to move forwards until there's certain academic validation and there's some feedback loops there. So you need to understand that timetable yourself. On the investment side, you can expect 3 to 6 months of being out there, meeting and greeting. You're on a roadshow basically until you get a term sheet. Now, once you get a term sheet, we would normally advise a week or two trying to get that negotiated. We tend to review them and get comments back to founders within 24 to 48 hours, because we know there's the excitement of getting things moving, but also, you know, investors do like to put a bit of pressure on founders. They don't want you sitting on that offer. They want to know whether or not they're taking that one forwards or not, and if not, they'll redeploy the capital elsewhere. Once your term sheet's signed, I would normally allow 8 to 12 weeks for legals. That's the same with the spin out. So with a university, you'll typically have a term sheet setting out the license terms, the equity terms. Once that lands in the hands of the lawyers, that's really the script for the lawyers to follow. It makes sense, therefore, to make sure that the term sheet is well negotiated and everyone's very clear on what's included and that they're happy with that, because that's what the legal documents are all going to be drafted to reflect. And you'll find there will be deals you can do much quicker than 8 to 12 weeks. But I typically, if you've got one party, if it's just a university, it might be quite quick to get the legals agreed. But there may be spin out committees that need to sign off on a certain thing at a certain point, and you've missed the window and you've got to wait for the next cycle to come round. Or with an investment deal, it might be that you're getting investment from 1 or 2 different syndicates, and then one of them might be match funding with Scottish Enterprise. So Scottish Enterprise have got their own lawyers, and then the other investors have got their own lawyers, and actually you've got 3 or 4 different groups of people all trying to negotiate, and that's where you want to make sure that you've got that plenty of time. So I think 8 to 12 is reasonable to close your deal.
Super, thank you very much. So I think you've also covered everything quite thoroughly, unless anyone has any last minute questions. Do you want to finally kind of talk about some other areas that you have expertise in that you could maybe look at in the future if there's interest as well?
Yeah, I'd be delighted to. So we were talking, I guess, just when you and I had logged in about some of the other workshops we've been doing. We regularly like to shout about and leverage our US experience, of course, given it's a USP. So we do a lot of workshopping on raising funds investment from the US, because if you're selling shares into the US, you have to comply with US securities laws, and there are important reasons to get that right. And a lot of that will be on the basis of convertibles. So founders may be running into advanced subscription agreements, they might be running into convertible loan notes, and they might increasingly be running into documents called safes, which are very much from the US, and are slowly infiltrating the UK ecosystem. So we do a workshop on comparing those. We also do workshops on general expansion into the US, which covers more commercial stuff and things like employment. I run workshops on share option schemes in particular. There's lots about share option schemes that I think is quite useful to hear from someone that's doing them regularly. I think we're probably working on around 80 share option schemes a year on average. And then generally sort of startup fundraising. So what should you be looking out for in a term sheet might be quite a useful workshop. I know we've had different input from investors and founders on this as well, but I'm always quite happy to give the lawyer's view. And of course, I've seen the term sheets across a vast portfolio of companies over the last few years, and also start to see some of the market trends as well in terms of things were a bit more founder friendly. We're very much now in a period where terms are a bit more investor friendly. It's harder to raise capital, therefore the investors have got a little bit more leverage on that. So they're a bit more risk averse, I guess. So happy to deliver workshops on any of those things for anyone that's interested. Of course, if you've got a particular transaction in mind or need a steer, you can reach out to me individually as well. But I think it'd be really useful if folk can let Cassidy know where you need more of the kind of one-to-many sessions like this, where we can get everybody in as a group and have a chat about something that's maybe affecting more of you than just one of you.
Yeah, we'll be sending out a feedback form after this, so if any of those sessions are of interest, then do let us know, and we'll be happy to get that organised.
Okay.
I think you've got another question.
A good question. Yeah, I see that one. So I would say the one that I've had 3 or 4 times this week is founders who I guess have been a little bit crestfallen, because they're like totally rocking and rolling on a great idea and everyone's behind it, and they've got investors who are like, oh, this is really interesting, let's have a chat, blah blah blah. So they're getting in touch with me as the lawyer, kick things off, and I'm going on Companies House and looking at the filings and going, it says you started with this number of shareholders, and then you filed something that says you've this number of shareholders, and where did all those shares come from? And then you filed something that says you've fewer shareholders. So where did those shares disappear to? Because you can't just they can't just disappear. And then I'm getting emails telling me all the story, and I'm like, guys, like this, it doesn't work like that. You can't just decide the numbers have changed and update Companies House. There are legal processes. Share capital, it kind of exists as a pool of funds for the company to pay its bills. So when you change your share capital, particularly when you reduce it, the Companies Act, the law, is very concerned about protecting creditors, not your shareholders, not your directors, creditors. If I go and look up a company I'm doing business with and I can see it's got £10,000 of share capital and I'm going to sell it £500 worth of pencils, I'm like, oh, okay, well, I know it's got 10 grand, it'll pay me my 500 quid. But if you suddenly disappear some of that capital, I'm being prejudiced as a creditor. I can't have faith in doing business with that company. So a lot of the Companies Act and company law is around protecting those creditors, and it does that by restricting what you can do with your share capital. You cannot buy back shares without being in a particular financial position, and there is a statutory roadmap you need to follow, for example. So I think, to be the bearer of bad news when those founders are really excited about this early stage of the business and the interest they've attracted, that never feels great. And I think, my warning to the founders is, if you're setting up the company, and it's just you and your sole director, you can probably get away with doing it yourself. But we do have a dedicated company incorporation team here, a company secretary team. They do nothing but manage filings, incorporations. We incorporate in the US as well. Just getting it right will just pay dividends, not literally, but you get my drift, in the future. And it's stressful to deal with it. I mean, sometimes we find people think that co-founder gave them a bunch of shares and then disappeared off to Australia, and it turns out they didn't. And actually that person still owns those shares, and we have no idea where that person is and how to get them. So what do we do? Do we have to start a whole new company and try and move the staff and all the shareholders over and the contracts and stuff? It's, that could be quite expensive. So I don't want to put people off starting a business, and bootstrapping is part and parcel of starting a startup. But if you're interacting with your share capital in any way, I think you're always worth talking to a lawyer, not an accountant. Talk to a lawyer, because the accountants can quite often think they know what they're doing and miss the legal process underlying these filings. And get a steer, have a chat with me. I'm sure a 5-minute call would be sufficient for me to say whether or not you do need somebody who knows what they're doing, or whether you're fine and you should just crack on.
Great, thank you so much, Alex. Well, if there's no other questions, we will leave it there. As mentioned, we will be sending out an email with all the contact details. So if you do have any other questions that come up after the session, then please do get in touch with the Entrepreneurship Centre or Alex. Both our contact details will be in there. But a massive thank you to Alex for hosting today, and for all of you for joining. So thank you, everyone, and I hope you enjoy the rest of your day.